Hearing the words fiduciary liability can sure make people cringe. No wonder. Fiduciary is a legal term, not well understood, and liability's bad. So what we hear is impending doom. Perfect for scare tactics, sales efforts. But not our purpose. This website helps fiduciaries get out of the way of a liability train wreck. It's why you were referred here. So, welcome. My name is Robert Toohey. I sold financial services to businesses for 30 years, and I wish I could tell you how that experience is so valuable you've just got to listen to me. But the truth is, my personal run-ins with regulatory lawyers and nuisance lawyers were so life-changing that I promised myself that if I could help others avoid what I went through, I would. I kept my promise, too. I created this website especially for retirement plan fiduciaries at small and medium-sized businesses to help you avoid being run over by a new and growing threat. 10 minutes on this video will save you weeks of work and very, very significantly reduce your risk. Let me show you what we do and how. Definitions matter, so let's clarify some terms. ERISA, the Employee Retirement Income Security Act, is the law governing retirement plans. ERISA defines a fiduciary as anyone with, key words here, authority or responsibility for the plan. All retirement plan liability is assigned to the fiduciaries. That liability is personal, I repeat, personal liability. A fiduciary's first hope for liability relief is that by paying the big financial institution, its liability is transferred. Not true. A contract defines what is exchanged between those parties. A financial institution's contract specifically denies that the institution has any authority or responsibility for the retirement plan. Services provided are ministerial only, which means the financial institution only follows orders, your orders. It is happy to manage the plan's investments, but accepts no responsibility for decisions regarding the plan. It is not a fiduciary to the plan and shares none of your liability. Sorry. A financial institution is a fiduciary for its own retirement plan, as the plan sponsor. Here's an example. In 2013, Fidelity Management, one of the world's largest mutual fund companies, was a fiduciary defendant in a suit brought by a former employee. The point is, a big institution can't stop its participants from suing it, and you, well, you can't stop yours from suing you either. Maybe those regulatory forms you file each year protect you. Nope, they're useless. Here's an example of why. In 2009, a large international engineering firm was a fiduciary defendant. It filed a motion to dismiss, arguing that it was compliant with all regulations. The judge denied the motion, said regulatory compliance was irrelevant. He explained that compliance with Department of Labor regulations was one thing, and that duty to participants, the issue before the court, was another. How about your old friend, the insurance company? Sorry, no help here. All standard insurance policies, bonding, directors and officers, employment practices, errors and omissions, etc., exclude ERISA fiduciary claims. Even if you paid for fiduciary insurance, the policy does not obligate the insurance company to defend you. If sued, the insurance company will settle, as it costs too much to fight for you in court. Word will spread that free money can be had just by suing you. The insurance company drops your coverage just before you get hit with multiple copycat suits. Here's a thought. It's the employer's retirement plan, not yours. Doesn't your employer pay your expenses? Sorry, no. Under ERISA, one of the 5 fiduciary duties is that a fiduciary must execute its duty solely on behalf of participants. Solely for participants means solely. An employer will claim that since fiduciary actions are not undertaken on behalf of the employer is not obligated to pay the fiduciary's legal fees and settlement costs. Gee, no one to the rescue. This is uncomfortable, isn't it? Let's go back to ERISA and look for any rules regarding removal of fiduciary liability. It's found in Section 410A, the section no one ever talks about. 410A says, any agreement which purports to relieve a fiduciary from liability shall be void as against public policy. 410A is free from ambiguity. No promise to remove fiduciary liability is allowed. Even if you had that promise in writing, it could never be enforced. The promise doesn't exist. Poof! And last point on rescues and escapes. You may think as a practical matter that you're too small to be sued. Me too. It doesn't work. Ever watch Wild Kingdom? Predators prefer unprotected or unwary prey. It's easy. Let's make very sure that isn't you. In summary, here's your position. No one takes your liability. They don't want to, and they can't. The only one coming to your rescue is you. So, Mr. or Ms. Fiduciary, it's time to consider who really would sue you and on what grounds, so we figure out how to avoid it or defeat it. Who may sue? 4 parties may sue. Only one will. Number 1, under ERISA, the Department of Labor may sue you, but it won't. It sues only after someone refuses to comply, which you would, not be stupid enough to do. Number 2, under ERISA, the plan may sue, but it won't. It sues only when employers don't make plan contributions, which you would, not be stupid enough to do. Number 3, class actions, first allowed in 1998, may sue, but won't. Plans with less than $50 million are very unlikely to be class action targets. That leaves number 4. In 2008, the Supreme Court ruled that an individual 401k plan participant could sue the plan's fiduciaries. The conclusion? Your only realistic threat is a participant or beneficiary from a self-directed plan like a typical 401k. Because the statute of limitations under ERISA is 6 years, former plan participants may sue too. This is a real risk, not theoretical, as the owners of the New York Mets discovered. Pretty factual so far, but may I interject an opinion? That a former employee might be very open to the idea of getting money from you in a lawsuit where the legal fees are paid on a you don't pay me unless we win basis. Next question. On what grounds would a fiduciary be sued? Answer. The only grounds allowed are for failure to properly execute fiduciary duty. ERISA names 5 duties. Number 1, comply with ERISA and plan documents. Your TPA and record keeper handle this. Done. Number 2, diversify investments. Done. Number 3, fiduciaries must work solely for plan participants. Number 4, expenses must be reasonable. Cheapest is not mentioned. Duty number 5, be prudent. It's prudent to hire experts for assistance and be on the lookout for conflicts of interest among those experts. That's could sue, the 5 fiduciary duties. But our concern is would sue, the real world. In the real world, most complaints against fiduciaries are considered frivolous and judges dismiss them. Courts consider 2 grounds as not frivolous but serious. They are fiduciary oversight of reasonableness of fees and conflicts of interest. Fiduciary documentation addressing these 2 issues is often inadequate or missing. A point, please. For a fiduciary to rely on its service provider's opinion of the value of the service provider's services is to rely on someone with a conflict of interest to evaluate its conflicts of interest. That sounds wrong, and is, and it won't stand up in court. You need your own oversight documents. We just defined the problem: lack of documents regarding the only issues that courts consider serious accusations. Here's a coincidence. Fiduciaries don't get sued for duties that are well documented. They're sued where documents are inadequate. Golly, do you think the nuisance lawyer knows that? Without documents, you can't prove a whole lot, can you? Get out your checkbook. And back to impending doom for a minute. A common scare tactic is to suggest that liability relief can be achieved if the fiduciary moves the plan to another provider. This is a baseless false claim. Moving the plan is actually firing the TPA, investment provider, or record keeper and hiring replacements. Doing so merely replicates documents regarding duties for which you won't be sued and does nothing to create those missing oversight documents, does it? Now, a quick look at litigation. Today, less than 5% of complaints go through a trial to get a judge's ruling. 95% are settled, dismissed by the judge, or go away. If you receive a complaint, you do not want to settle. You can't afford to settle. The copycat suits from other participants would plague you. You need a dismissal. If you present a judge evidence demonstrating your proper exercise of fiduciary duty, the judge is unlikely to grant a trial. No longer can your opponent merely accuse and wait for a payoff. He would actually have to prove something, which means he will go away looking for more unwary prey, or bigger prey, a class action where the payoff warrants the fight. Not your problem. This concludes the first video, defining the problem. You must feel better already. In just 10 minutes, we have defined the vulnerability, eliminated rescues that cannot happen, and false claims of protection, and described the documents you need. Whew, that's a lot. Oh yeah, almost forgot. You need some documents built, don't you? I'll see you on the next clip.